2025 to take leave on the offense of offensive conduct conducive to breach of peace, contrary to section 94, subsection 1 of the Penal Code. The particulars thereof has been succinctly set out that on the 8th day of July 2025 at Nairobi City, within Nairobi County, being in a public gathering, uttered words for which, open quote, I want to talk about Naivasha because I know those goons were transported in NYS bus in a place called Karangita. They were dropped there. In town, they were brought in trucks. In my mind, so all these people, nobody knew them. As I condole with the bereaved and also empathize with those whose properties were destroyed, I want to tell President Ruto, this is not a war. You can win unless you want to destroy this country. It is about the youth. It's about young people who you went around promising heaven. And what you are doing now is digging deep so that they go under. It will not happen. In Naivasha, they killed one, 3 in critical condition. And as my colleagues have said, police are doing anything. They didn't try to arrest the goons. They're not doing anything. They didn't try to arrest the goons. You could see in the place goons working with them. So it is not anything that is going to end. We as Kenyans are prepared to prepare our country so that you cannot. We as Kenyans are prepared to prepare our country so that you cannot be drowned by one single person because you think you're so powerful, yet you have the power which we give you. You cannot use the same power to destroy us and destroy the country. End of quote. I'm quoting verbatim with intent to provoke breach of peace. So I take judicial notice that the suspect is a sitting and currently member of parliament representing the Naivasha constituency. The suspect was represented by a battery of counsel. They were led by Dr. Kalonzo Musyoka, Senior Counsel, Mr. Maturi, Mr. Kihara, Mr. Kiragu, Mr. Ndego Njiro, Mr. Wairegi, Mr. Malemba, Mr. Nyambu, Mr. Wabugu Wajohi, Mr. Mageto, et al. They got the number. So the state, on the other hand, was represented by Ms. Nora, Mr. Witty JV, Ms. Sonia, and Mr. Momani. So in its application, canvassed orally on the 18th day of July 2022, counsel for the suspect have vigorously opposed the suspect from taking plea. So that is the kernel and quintessence that this court is called upon to make a determination on. Dr. Musyoka, Senior Counsel, has urged that on the partial glance of the charge sheet, the suspect is charged with the offense of offensive conduct, contrary to section 94, subsection 1 of the Penal Code. Senior Counsel has ruled that this is purely political persecution and that the alleged utterances falls within the constitutional realm and orbit of freedom of expression and press, and furthermore, the particular does not disclose any offense. He poignantly supplicated that other people or politicians have said worse statements, thereby imploring selective and or discriminating prosecution. Senior Counsel was appalled by how the arrest was conducted in terms of the public resources used and the numerical force that was used against the backcloth of the misdemeanor charges that now the accused has been arraigned. And therefore, he espoused that the acts by the enforcement agency were all unconstitutional. On his part, Mr. Kihara beseeched the particulars of the offense as well do not disclose the ingredients and were unconstitutional. He submitted that being a member of parliament, the suspect was a mouthpiece of our constituency and which she exercised by dint of Article 33 of the Constitution. Mr. Ndego Njiru guarded this court on the enforceability of rights within the refraction of the constitutional imperative and the dictum vis-a-vis the statutory provisions and the doctrine of stare decisis. He entreated that pursuant to Section 8(1) of the Magistrates Court Act, this court is closed to the jurisdiction to hear and determine applications for redress of a denial, violation, or infringement of, or threat to, a right or fundamental freedom in the Bill of Rights. He thus urged the court to invoke Article 33 of the Constitution in delineating whether the charge sheet borders on a threat to a right or violation of fundamental principles. Further, Learned Counsel Mr. Njiru, a most stringent argument is that the statutory provisions must be symmetrical and harmonious with the Constitution by dint of Section 7 of the 6th Schedule and Article 10 of the Constitution on national values and principle of governance. He thus avowed that this court has the jurisdiction in entertaining the instant application relating to the threat, the denial, or violation of the suspect rights in the contextual milieu of Article 33 of the Constitution on the freedom of expression as juxtaposed with the Section 94(1) of the Penal Code. He buttressed further that the particulars do not disclose an offense for the suspect to comprehend to the charges she is facing. Counsel further argued on the limitation of rights and fundamental freedoms under Article 24 of the Constitution, submitting that rights of fundamental freedom cannot be limited only to the extent that the limitation is reasonable, justifiable in an open, democratic, and civilized society. Counsel also made reference to Article 19, 20, and 27 of the Constitution. On his part, he said that Kiragu extensively submitted on the composite of the offense that the suspect is facing, basically urging that the three ingredients to the offense has not been disclosed sufficiently, concomitantly offending Article 52(b) of the Constitution. The Learned Counsel, Mr. Wambugu Wanjoy, iterated that the charges were not warranted since no clear offensive conduct had been identified, with the charge sheet being broad, vague, and ambiguous. He adjured that Section 94 of the Penal Code criminalizes conduct and not political opinion or opinions, and with no nexus between the words alleged uttered with the breach of peace. Conversely, on behalf of the state, Mr. Whitty vehemently opposed and backed the application. He unerringly submitted that jurisdiction is everything, reverberating the old aphorism that a court of law down its tools in respect to or matter before it. He reverberated the old aphorism that a court of law down its tools in respect of the matter before it, the moment it holds the opinion that is without jurisdiction. On the jurisdictional question of Section 881 of the Magistrates Court Act, Learned Counsel argued that under Section 828, Section 2 of the said Act, this court's jurisdiction is stringed and hamstrung to rights under Article 25A and B of the Constitution. Corollary, excluding Article 10, 19, 20, 27, and 33 of the Constitution. He further argued that Section 94(1) of the Penal Code is in force and applicable in collocation to Section 7 of the 6th Schedule of the Constitution. He exhorted that, pursuant to Article 2,